It is 6 o'clock. I call this meeting to order. Go ahead and stand. Start with the flag salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, and for roll call, Commissioner Boyle.
Here.
Commissioner Whalen.
Here.
Commissioner Sweat. You?
Oh, here.
Yeah.
Give me yours on you.
Commissioner Johnson, it sounds like has called in.
Yeah, she emailed in and requested to be excused. She is out of town.
Okay. Commissioner Zaro,
Here.
Vice Chair Oler,
Here.
and I am Chair Elliott. Do we have a motion to excuse Commissioner Johnson?
So moved. And seconded.
All right. So we have a motion that has been seconded to excuse Commissioner Johnson. All those in favor?
Aye.
Aye.
Any opposed? All right, motion passes. Okay, and then moving on to any additions, deletions, or corrections to tonight's agenda. Yes, Commissioner Whalen.
There was an email that Manager Stallnecker had sent out about additional meetings. Could we make that as a topic? I didn't see it listed. I could have missed it, but.
Yeah, we can do that as 7C.
Thank you.
Is that okay with everyone? I figure I'll just check for consensus there. Okay, I see heads nodding. Okay. I'll go ahead and open it up for citizen participation. We have no one present, so we'll move forward to approval of minutes for August 14th, 2024.
Move to approve the minutes for August 2024, August 14th, 2024.
Can I get a second? Okay. Motion has been made and seconded to approve the minutes from August 14th, 2024. Any discussion? Commissioner Whalen.
Just would be interested in learning from fellow commissioners if they'd like to see added to future minutes the address or that we're in council chambers. So something about our minutes that actually lists where the meeting takes place. And the other thing is I'm noticing that our minutes are becoming more brief, and I can appreciate the concept of action minutes. But under regular agenda A, there isn't even a mention of the sections that the Planning Commission gave comment on. And I didn't know if that was an issue that mattered to fellow commissioners, or I guess it's a comment or a discussion for a retreat sometime about the level of information in minutes. But so it's just a general question to fellow commissioners. They're not errors, but.
So just opening it up to the floor, as far as does anyone have any further comments or concurrence with the comments?
I think it would be helpful to have the address or even links if possible. It looks like this is on letterhead, standard city letterhead. Maybe we can simply update the city letterhead to reflect the location.
Not opposed to it. It does follow the same format as city council, so that's usually what I go with, but it's just a template, so.
Okay. So it sounds like maybe we just if you can talk to whoever sets up the template and see if it makes sense to add it. I don't think it necessarily needs to be a stamp it in place, but if that's something that city secretary or anybody else wants to look into. In regards to the depth as far as the meeting of the agenda and the staff reports, acknowledging that we now have video recording that's supplemental to the minutes, I'm comfortable with how it's presented currently. And it's moving forward with kind of how city council has started proceeding with minutes as well, from what I understand. Okay.
Yes, we're trying to follow Robert's rules and the recommendations of AWC and MRSC, which is to make it as basically action minutes. So you just recording the action that's taken, not discussions and stuff. So
Mhm.
sometimes, yes, sometimes I have put, council directed. I didn't feel this, I guess this time it seemed like it was mainly minor stuff, so I didn't include any of that.
Okay.
I mean, one more thing that could be helpful is I see that it says this meeting is now live streamed. Visit our website and click on our calendar event for the link. Actually embedding that link could be helpful. Just a suggestion.
On the agenda.
Yeah.
Yeah.
Okay. Great. So with that, a motion has been made, seconded, and discussed. If there's no further discussion, we'll put it forward to vote. All right. All those in favor of approving tonight's minutes, or to approve the minutes of August 14th, 2024, say aye.
Aye.
Aye. Any opposed? All right, motion passes unanimous. Okay, now we will move it on to the public hearings. First public hearing is agenda item 6A, which is the comprehensive plan, transportation, capital facilities, and utility elements. Did you want to state anything before I go into opening?
Just that, the planning, so when we did the public hearing on the comp plan, it didn't have, those three elements, at least not in both sections. And so, those have been added. There will still be, which we'll get to in there, but yes, so we just want to make sure that we are properly, going through the process. And so we wanted to make sure that those three elements got identified, and had a public hearing.
Okay, so I'll start off with agenda item 6A, comprehensive plan, transportation, capital facilities, and utility elements. I will call this meeting as opened at 6:07 PM. We have no one attending, so we will now also close that at 6:07 PM. Moving on to agenda item 6B, permit procedures, chapter 17.62, 17.65, 17.70, and 17.71. It is 6:08. I call the public meeting to order. Again, there's no one here, so we will close our public meeting at 6:08. Don't know if the gavel's necessary, but I figure it's very official. All right. So that closes the public hearings portion of our meeting tonight, and now into our regular agenda, 7A, 2024 Comprehensive Plan Development Code Update continued. And with that, I'll turn it over to staff.
So, if the planning commission is comfortable tonight, making, again, we've recommended the bulk of the comprehensive plan. If you're comfortable tonight making the recommendation on these draft elements, that can be done tonight and move forward. We probably won't be holding a city council public hearing on these until closer to the end of the year. And I do anticipate there will be some, we're still waiting for a few updates from some capital facility numbers to make sure we've got the most current, and some transportation. So we can make the recommendation tonight, and then we will, if any additional things come in, we can make sure that council's aware of that. Alternatively, we could hold off on these three elements and make the recommendation the same time Planning Commission does for the zoning that Framework is working on. We could do those also both at the same time. So I didn't know if you were comfortable enough, we can just kind of move that on, and then we've taken that off. Like I said, alternatively, I believe November is when we were hoping to do the public hearing with the Planning Commission for the zoning, and then make a recommendation on the zoning stuff. So at that point, it would be at that point. So.
Okay. So I guess first is just a check on if everyone's reviewed it and feels comfortable with what's in there so far, based off of the conversations we've had. Then we can decide. So we'll have that discussion first. And then the next point of that, once we've closed that part, is are we comfortable moving this forward now, or would we like to hold this until we get the other portion of the comprehensive plan update, correct? Oh, okay. So if that works for everyone, let's first just discuss if there was any feedback or comments based off of the latest round of updates. And if it's okay, I will start at Vice Chair Oler on your side of the bench and just work our way around.
I don't have any comments at this time. I'm still looking over the appears to be extensive updates, deletions and additions. So knowing that I was absent last time, I'm not really up to speed on what you discussed.
Oh, you probably are we'll start it with Commissioner Sweat. I'll move it to you next. It's like, that's
I
a
have
good point.
nothing
I
at this time.
apologize for that. All right, Commissioner Whalen.
I did not get to really delve into complete the reading, so I would be abstaining if the majority of folks said we want to vote to send it on, because I
Okay.
haven't finished reading it, so, thank you.
Yeah, I would second that. I don't have any comments at this time, but I would not oppose to having more time to review it.
Okay.
If schedule allows, I'd like to maybe discuss this next month. I made it through the transportation, but I have not delved into the capital facilities or the utilities yet. And is the Parks, Rec, and Open Space separate from capital facilities, or is that included, or how does that work?
So that was in the previous bunch that we recommended, that the Planning Commission recommended a couple months in May, or we made the recommendation in June. And it was basically a pretty close copy of what was adopted by council as the pros plan. Obviously, if there are any errors or things that come out of your review that we feel could, again, I don't anticipate council adopting until December. We're going to be right up there, but some cities aren't going to make it till next year. So we're doing great. They're going to be late. So yes, so the parks was already reviewed and recommended by Planning Commission, but if you find things, feel free to let us know that you feel like we need to look at. So this is the only thing we hadn't done officially was transportation, capital facilities, and utilities. And yes, if we wanted, like I said, there's no, at this point, we're okay if we want to give everybody a little bit more time to kind of look through. And there are, like I said, there's still a few capital facilities portions that we're fine tuning. So.
They're pretty basic,
And most of what's being,
but I don't remember doing the Parks and Rec and Open Space. Maybe I was gone that meeting.
it's probably not as exciting as the land use was at the time, so.
If that's what you think is exciting.
Like I said, and most of what's coming in here is just updating the numbers.
Yeah,
Making sure that we've got the most current, that's both.
but would we have time to review and report between now and October's meeting and then bless it then?
Yes, yeah, we can do it at the October meeting. We could also do it, and that's when we talk about some additional meetings, we're gonna have to shuffle a couple of meetings around. So we can definitely do it in October, or at worst case, 1st of November.
Yeah,
So,
I just
okay.
like a little more time to review that part.
Okay, great.
That's okay.
Sounds good.
So based off the fact that there's not a lot of input, and everyone's seeking extra time, it looks like we're going to hold this for.
Yeah, and if you do have things, you can either use the Convio still, so that you see what other comments have been made, and Framework gets it directly, or you can always just send me stuff and I can forward it on if you're having trouble with that or don't have time for that. So.
Okay, great. So with that, since there's no motions or action items there, we'll go ahead and move on to agenda item 7B.
Okay, so yes, so since, and I had talked to Framework just why again, between waiting for a few things, they were comfortable coming back in October and so with both the zoning and anything else on this, if there's questions. So that left us time to hopefully maybe get closer to finishing up the items in chapter 17 for permit processing that we're working on. So just identifying some of the things that did go from the last meeting. We did add some language in the site plan in 1762 that to address addressing bicycles, noise, and pollution. Added language to require that the applicant is going to place signage on properties. And I thank Commissioner Boyle for giving me some links to what I think it's both King County does. I looked at what Tacoma does, so we can up what we require for signage. Kind of revise the language to expand that a neighborhood meeting can be requested by both tenants and businesses within the notice area. And that also included language that says if a project is going to require off-site improvements, that those tenants and properties will also be required in the notice for type should be 4 and 5. So I got my Roman numerals backwards. So, so in the case, basically that's the case of like for the warehouse project, because we knew we were going to require them to do all of Fifth Ave as part of that project. In the future, that area of 500 feet or 1,000 feet would be required for notice as well, both property owners and tenants, because it would affect them. So those have all been added. I do know that we really didn't, I believe Commissioner Whalen had commented, because we kind of ran out of time, about we really didn't discuss variances. So I don't know, and the applications, I don't know if we want to
Focus
kind of
that
look,
over there.
start there, focus on those and kind of look at those.
Yeah.
So for Commissioner Oler, who was gone, basically, part of this comes from the fact that the state is requiring us to look at streamlining. They're trying to get projects to go through faster. I've used that as an opportunity. I mean, some of it is they've changed some of their deadlines, but there's also sort of of the overall intent of that. So I've used that to identify things that I feel like, which I think we've talked previously about, how, what makes the most sense for review depending on the type of project. Because the more review you have, the higher up it goes, the longer it takes and the more expensive it is. What's the appropriateness of that? So, oh, real quick, on page 8, before we go any further, I did also, there was questions trying to clarify the difference between site-specific rezones, trying to understand that better. And so I did include, you hopefully in your packet, you received an article that sort of outlines, I kind of took huge chunks from an MRSC article from Phil Albright.
Page 49.
And so basically, again, the idea is that, and then I tried to do a little comparison table to show why I'm recommending we move it to a type 5, which type 5 we have right now has planned developments and special use permits. So it's in essence, it's a hybrid, but the vast majority of it is going to feel like a project. It has a specific application. There's we recommend a pre-app meeting. We're going to do notifications. So basically a site-specific rezone is somebody comes in and says, I have this property. It is currently zoned under our new stuff. It's currently zoned neighborhood, or is it neighborhood? I don't know. I'm gonna have to learn them all. Commercial, and I want it to be light manufacturing, and I have reasons based on the criteria that I believe that should happen. So that's a site-specific versus what we're doing right now is the Planning Commission as a whole is looking at the whole city. We're doing it citywide, so it's legislative. You guys can talk to whoever you want. We can engage the public as many times as we want. We do public hearings. We give it to council. They have all that freedom. When you have a site-specific zone, it's in almost all but kind of the end is just like a project application. We notify everybody within the boundary. We may encourage a neighborhood, it says it's encouraged, so in most cases, we're probably doing a neighborhood meeting. You're only allowed one public hearing, and it's what's called quasi judicial, which means whoever is reviewing that first hearing and who makes the final decision has to act as a judge. So it can't be just, well, I like it, I don't like it, which really we can do at the legislative letter. We can say, hey, we want this area to be residential, we want this area, and we don't necessarily have to have a lot of rationale behind it. In this case, there's criteria in our code, and if they meet the criteria, we have to say the planning commission, if they're the one recommending, hearing examiner, if they're recommending, and then the city council as the final decision. If they meet the criteria, it has to be approved.
Mm.
And so it's the only difference, like I said, from a project, and actually it basically mimics what we do for special events. So like with the plan development, hearing examiner held that hearing, made the recommendation that it met all the criteria and that these are the conditions. The council reviews it. They call it a closed public hearing. Basically, they just review all the hearing documents, and then they have to make the decision based on the criteria. It's the exact same thing we do for site-specific zoning. The only difference is, and this is that you can decide which you prefer. Right now, under our current code, the planning commission holds that quasi judicial hearing and makes that recommendation. That's fine. It doesn't happen very often, but as long as you feel like the challenge is that the 7 of you have to keep in mind that this is a quasi judicial, it's a different role and you have to meet the criteria. Alternatively, you could make it the hearing examiner, who is kind of trained to be in that quasi judicial mode, make sure that we hit all the legal stuff. Again, it would fall into that same category that we do rely on the hearing examiner for other things, and then it goes to city council. So one, I hope, and again, the document I give, I hope that explains why it's different. And then again, I would love to have, if there's some consensus direction on whether you want to keep it at the planning commission or you want to change it to the hearing examiner to and again, they both have their pluses and minuses. Like I said, because I'm sure the reasons that we have the plan development and special use permit is that way there's probably less risk, less liability.
So
So-
point of clarification, the hearing
Yes.
examiner, my understanding is, I think you explained before, that is basically like a contract adjudicator that comes to work for the city. It's not the county hearing examiner, correct?
We have
Okay.
a contract. She's a land use attorney. Ours happens to be, currently is Susan Drummond. She's a land use attorney. She's currently works for the City of Seattle Hearing Examiner Services. We have a contract with the City of Seattle. They are willing to contract with smaller jurisdictions that are in King County, and our little jot into King County allowed us, and I had worked with her at a previous jurisdiction, so I was happy that she was willing to work with them to get a contract for us. So yes, and that's what they're trained to do.
Okay. So I guess any questions or comments about this table and anyone's thoughts on whether this should stay in the planning commission or if there's a preference to go over to the hearing examiner? If it's okay, I'll go ahead and start it off with Commissioner Boyle, just trying to switch it up.
I know my limitations and when to stay in my lane, so I have no problem with the hearing examiner. But this all, of course, depends on the consensus of the rest of my commissioners.
Commissioner Zaro?
I agree with that. I'm wondering what the cons are of switching to the hearing examiner.
I guess theoretically you're giving it to somebody else, though, because it should be under strict criteria. That should be, I mean, my recommendation would be to go to the hearing examiner, because what the planning commission being in the legislature, you get to set that criteria, which we have. So I think ideally you would give it to the hearing examiner, and then if you had concerns over the criteria, then we would look at the criteria. Now, I know state law and the courts sort of have dictated that. I don't know how much we can go beyond that, but it is something that's usually where we prefer the legislative end of it does, is, you know, give it to the hearing examiner to make sure they meet the criteria. Your job is to make sure the criteria is what you guys want for the city.
Mhm.
So, but that theoretically, that would be the idea, is that you're giving it to somebody
Okay.
else, would be the only con.
I'd also imagine it would be quicker to have the hearing examiner look over it than all of us. Is that?
You're under
Do
a
you
time
think that-
sign, so yeah.
Okay. Okay, yeah, I'd vote to move it.
Or you're just recommending? Okay,
But it's not cheaper.
yeah.
Not cheaper. There you go.
Yeah, the drawback is the cost to
So
the
we try
city,
to build in
but
some of those
yeah,
costs so the applicants are paying for
yeah.
stuff.
Continue around the table.
So on the question side of things, I wanted to learn by looking at page 30 of our current packet, and I see under process type 5, the red ink indicating a new change. And when I was reading page, I think you said 8, yeah, I got the impression that we have something already on our table that's specific to site-specific zoning map amendment. Because there's a question about quasi-judicial 5 versus legislative 6. I just do,
Yeah, so right now, under our current code table, so if you're looking on page 30, the process 6,
Mhm.
our current one just says zoning map amendment, chapter 17.68. And then when you go into the secondary table and you went down to the language, it was trying to say, these are the rules unless it's a site specific. These are the rules unless it's a site specific. So it was trying to do both in the language. So if you, on the red line of, let's see, if you go to the red line of, let's see, on page 37, it does a lot of, a notice of application shall be prepared and distributed for site-specific zones, but not for any other type. So it was sort of this trying to do both. Well, when you, like I said, when I go through it on a table, it's basically everything that we already require in process 5. So it makes it, to me, it was cleaner to say this is process. It's just like process 5. And then again, whether we keep it, that would just be one change if you didn't go the hearing examiner. And then that leaves everything for process 6, which is legislative, which is what you guys do. It's the comp plan, it's the regular zoning text amendments, which are all what you choose. You know, like I said, it's legislative, it's not quasi judicial. Everything else in process 5 falls under that, like I said, that quasi judicial. So I think it led to confusion unnecessarily.
okay. So I can see why it would fit under process type 5, because back in the days when Phil Olbrecht was our land use attorney, he would give some clear education and say, you know, when it's site-specific and applicant-specific, you do not talk about, I mean, there's all this is quasi-judicial. So I can see your point about, well, they're both rezones. One's a area-wide zoning map and site-specific, well, and that would be the distinction, site-specific, applicant-specific. So I'm okay with it being added and delineated from a citywide zoning map. The one thing that I would, in addressing what are the cons of things going to a hearing examiner, when I started on the Planning Commission, we did a lot of quasi-judicial decisions, a lot. The date escapes me when we made this change to take away a lot of decision-making authority by the Planning Commission. And while I see the risk assessment perspective, it really, I would say the con of it going to the hearing examiner is, as a planning commissioner, you lose the insight and the experience to see how your code is implemented, because you were part of the process of reviewing the documents, seeing everything. I mean, it made the job as a commissioner far more interesting from the perspective of, this is why this works this way, this is what could be made better. It made for a far more interesting, rather than our really just sticking to the words. But I understand the risk assessment decision. I would say, is there a way we can include the opportunity for the planning commissioner as a whole to submit a recommendation to the hearing examiner? The hearing examiner would be the decision maker. That's where the open hearing is. But could we, as a planning commission, because you would know when these things come up, could we do something where the commission could weigh in?
I can ask the attorney.
Okay, because I got that impression from the article, and I'm sorry I didn't highlight it to have it jump out at me right away, but I got the impression that the Planning Commission, and I think it would be a great opportunity for us if it was possible. Again, that might interfere with time, but, we had special meetings for hearings so that when you had to meet those clock dates, we were right in, working in tandem with staff to get these decisions made. So I would agree with the hearing examiner as the decision maker, making it a process type 5, and really hope that we get the opportunity to compose a little report or something to the hearing examiner.
I'd be happy to ask the attorney, and I will also add that I have sent all of this to him. So prior to the next meeting, before the vote on recommendation, if there's anything that he wants to change or suggest, you will get to see. So I'm trying to find that fine line with him, and I'm getting closer, I think, to finding that right spot where he comes in and looks at stuff. So, and if not, again, I am curious, because if you look at the, basically, we just have what the state has for criteria, or what the courts have established. I should say that the courts along the way established sort of some basic criteria. I don't know if we can expand beyond that or not. So I can also check in and see what the attorney says about that. Because my understanding is it has to follow the criteria. So can we have additional criteria? I don't know. So I can ask him that too.
You anticipated my question, which was, where is the criteria
Yes.
for site-specific, applicant-specific rezones, and what's expandable?
Let's see, where are we? It is, so it's under zoning is 17.68, and says for site-specific rezones, and again, this is basically, if you read the article, it's almost verbatim what he said the courts have said. It must have a substantial relationship to the public health, safety, morals, or welfare, must either implement the comprehensive plan, or a change in circumstances must necessitate the rezone. So if it agrees with the comp plan, it doesn't have to necessitate, it doesn't have to meet that criteria. I will say that if their site-specific rezone does not agree with the comprehensive future land use map, it does not meet the criteria and it won't get approved. And the Planning Commission does get to recommend that. So the only time this would come into play is if we had two zones under the same comp plan over, so if it was, if under neighborhood residential or under like uptown business, we had two zones, then they could come in and switch from one to the other. But if the future land use is uptown commercial, and they're like, hey, we want to make it multifamily, and that's not a zone that we allow under that land use, future land use map. Again, think of that one over the top layers, then it wouldn't meet criteria. So that's, again, it doesn't allow them to just drastically go over because they would have to come in for a comp plan change. Well, that stays legislative. So site-specific rezones are pretty rare, and it would be pretty rare for this city because most of the time we don't have that many multiple zones under what the comp plan allows. So, but that is where it is. It's at 17.68.
Thank you. Another question is, a site-specific rezone would be asking to change the zoning, not the future land use map designation, correct?
Correct.
Okay.
So if they want to change the future land use map, that can only be done once a year as part of your normal comp plan update. And if
Okay.
it doesn't, and that would come to the planning commission as a recommendation, and it is not quasi judicial. So you're allowed to say, no, that's not what we want for our city, is to change that area. So it's a real finite where you can use that site specific zone.
Mhm. And we've had a few over the years, um, before we had this level of sophistication that's coming soon. Uh, The question in my mind, or the thought process, thinking right now, the future land use map, as it's proposed and forwarded to council, has merged the residential moderate density district and the single-family zone. So and there's very big differences between minimum lot sizes. Assuming, and it's a big assumption, that what's coming back from framework is that lot size concept is going to stay. 4,000, well, I won't go into numbers, but so the concern I have is someone looking at a future land use map designation, neighborhood residential, and you have an area that's got a much higher density, a smaller minimum lot size. I envision this popping islands in around. And so it's an interruption in the pattern of development. And so that would be a question to direct to the attorney to understand, or maybe there's there is a rule in place that says, well, if you're going to change, you've got to be adjoining an
And
existing area.
I know other cities have that. And so that's definitely, like I said, that's where it comes into those criteria. So it may be something where we want to look at that criteria next year and expand it to say things like you can't do what they call pocket zoning. Like, yes, if you're going to do it, you have to be kind of adjacent to that zone you're requesting. Things like that. Or it has to be a certain size. So, if it's, for some reason, we have something that's 100 acres that they want to, well, that'd be different than something that's 6,000 or 8,000 square feet, So, yes. So we can, I know, again, that makes me realize there is definitely a few more criteria we could add to put some parameters around that on the rare occasion that it would be eligible.
Yeah. So because I see 1768, thank you for locating that in the zoning title. It's less than a page of criteria. I mean, the criteria is so
And
general.
really for site specific, it's just E.
Yeah.
So yeah, I think we should,
So that would be a key question with the attorney, and maybe it has to happen
Yeah.
later, but to answer the questions at the table at the moment, I think I've answered them in terms of yes, process 5, yes, hearing examiner, and wish list, expanding criteria, and learning what the criteria is, and I forgot what the other wish list was.
Yeah.
Forgive me.
no, I've got notes. So,
Thank
okay.
you.
Commissioner Sweat, any comments? And then also the question about if you have a preference between the site-specific rezonings being under the Planning Commission or Hearing Examiner for recommendation.
Well, for the second part of that, I would say, I like her idea with the planning commission, or with the hearing examiner. except, I just think, the commission here should touch on it first, and then we could decide whether or not we need to do that. Does that make sense to you?
Yeah, I think what I'm hearing from the group a little bit is when it comes to the judicial or quasi judicial process of does it check the box, yes or no? That probably should be under like a hearing examiner, someone that's a third party. But when it comes to that level of transparency, I think that's the piece I'm hearing that a lot of people are craving as far as if there is a hearing examiner judgment going out, we want to at least be privy to it. We'd probably like to have that as part of our monthly reports or something like that, that if something is something related to land use is going to the hearing examiner, we want to be made aware of it so that even if we can't catch it in time for this, we can start taking action like we did with the churches and stuff like that, where we kind of weren't in a position where we could say, hold, stop, we want to put a moratorium before this can get any further. But at least be able to say, if we don't like it, what are our options? Is that kind of what I'm hearing from the
Yeah.
group? Okay.
And for the rest of it, I'm limited in, knowledge about a lot of this, but I have confidence in our planning manager and the rest of the commission here. I'm good with the way it is.
Okay.
Thank you.
Thank you. All right, Vice Chair Oler.
I agree with wanting awareness and insight into what's being brought for site-specific rezones. I am nervous about the liability part, that we could leave the city of Milton open to, it looks like a tortious claim from what I'm reading here, and that is a fine. So for that reason, not being judicial, having any experience in that at all, I'd recommend going to a hearing examiner just to cover the city from liability, but also stating, yeah, it would be great to have insight into any site-specific rezones brought before them.
So I think the consensus from what I'm hearing is site-specific rezone recommendations would be made by the hearing examiner, and that you'll look into if there's any way
Yes,
we can be added either to
I will-
reports
I
or.
will talk to the attorney about, one, what can we add to the approval criteria? Because I think it's pretty vague. I mean, it's the bare minimum. And I think we can add to that, which would, I think, be helpful. And then see whether it's at least making the planning commission aware prior to the hearing, or whether that the body can have an opinion or something with that. So I will look into those items.
Okay, great. Yes, Commissioner Whalen.
Additional comments based on subsequent comments. Another thing that the Planning Commission of old got to do in discussing things with an applicant was, yes, there was criteria, but the Planning Commission, as a representative of the community, could say, well, could you do this? It was, yes, there's negotiations, for lack of a better word, between staff and applicant. But I can remember site plan approvals. I can remember, questions that we asked when it came to rezones. There was an opportunity for some give and take, and between the applicant and the Planning Commission, where the applicant would say, "Oh, I could do that." So that's another con or downside. The other of it going to a hearing examiner. But the other issue is the conditions of approval. The Planning Commission got to add conditions of approval in our quasi-judicial decisions. So that became a way to fine tune, and we brought up things that staff hadn't considered, and the applicant was, that's fine. But I know we're talking about site-specific, but on that general topic of what, pros and cons of the hearing examiner process. And the other comment to make is, we can attend hearing examiner hearings. They're here during business hours like 10 o'clock or 9 o'clock. So for people working, that's tough. But letters could be submitted. And requests could be made for additional conditions added to something. So there is a way, and I'll just give a pro tip, is whenever we go before, especially in a quasi-judicial situation, and we go to the podium to speak to the hearing examiner, or even addressing counsel, it is important to identify the fact that we're speaking for ourselves as individual citizens with a lot of experience. We're not speaking on behalf of the Planning Commission. And that's an important, just bear that in mind in any correspondence or testimony to make that distinction. I did that a few times, and the hearing examiner that we had at the time said, right, you did it right. So it is a little more of an official judicial situation, and so just bear that in mind if you give testimony. Thank you.
Great. All right, with that, moving forward.
Yeah, so I didn't know, so I think we kind of left off with 17, oh, I guess 65, which is variances. I think I did a quick zip through, but we really had run out of time. So, yeah, so basically the idea is the planning commission had asked, or at least had mentioned, at least one or two members had made the suggestion of creating maybe a minor variance. And so that's what this does. The minor variance, again, right now, what I put in here is trying to differentiate the two. Is a minor variance is one that does not exceed 20% of the standard. So if the standard was, let me see, no, I don't want to do math in my head. It gets me in trouble. So if,
So if it was 50 feet. And
so if
60
like the frontage is 75 and they wanted anything between like 70, basically if they wanted up to, what did I say? Does not exceed. So if they wanted anything within 15 feet of a reduction of that, a variance of that, that would just be a staff level review. Again, that number is not magic. I tried to, some were as low as like 10, some were as high as like 35. And so I just sort of picked the middle. But that, depending on how much, again, how much authority you want to give staff versus how much you want them to go to the hearing examiner, that number can shift. So again, there's criteria. It's not just whether or not the hearing examiner or the staff person wants that, but it does allow, it is nice for certain things. And again, you can decide where you want that number to be. But right now, the only variant, we allow one variance. It has to have a neighborhood meeting. It has to go to the hearing examiner. So sometimes it's something really small, like a couple feet, or maybe they're trying, and they have good reasons why, but they have to do all of that. So in this case, like I had a gal in the other day who they were looking at, they wanted to put in a accessory structure, just basically a shed. Well, because of the way their property has this hillside, the way they thought they were going to have to encroach into the side setback about a foot. Now, we ended up, when we looked at the property lines, ended up not needing to. But in that case, if they had wanted to for that foot, they would have had to, if they wanted a variance, they would have had to go to the hearing examiner for that. That seems something that's small enough that could meet the criteria. It's not just that they wanted it in the setback, there was actual slope issues and stuff. So that's why sometimes it would be nice to have that minor variance where the staff can do it for those smaller exceptions. And then if they want something major, then they do have to have the neighborhood meeting, go to the hearing examiner and stuff. So the one thing is is that percentage, like I said, I've seen it as low as 10, I've seen it as high as probably 35. And then does the criteria, the minor criteria make sense? And I try to, again, the major, I also am recommending changes to the major criteria. Honestly, I think my intent was to make it a little less subjective and a little more object. Sometimes I feel like it's almost a little wishy-washy of, so, like there actually has to be, you know, in certain ways. So anyway, I will stop talking.
Point of clarification on page 14, A minor variance, the community development director, that's,
That's me.
yeah, it's just
or-
a different name, so I'm like,
Yeah, so, yes.
okay.
We don't have a community development director, though most of the time the code uses that term, so I'm trying to stay consistent. In this case, I am assigned to be that role when the code
Calls for
expects it.
that.
She
Well-
wears many hats.
Yeah, I mean, in some places it says other things. Some of it
Just
says
curious.
building and planning I mean, there's all over the place, so. That's the one I feel like is used the most, so yes, that would be for, in this case, the planning manager serves as that role for those decisions.
Okay. All right, so any comments as far as just the minor variance, like the percent? How does everyone kind of feel about that 20% threshold for minor versus major? Yes, Commissioner Whalen?
So on that question, I think the 20% is too high a threshold. And I have seen codes that have gone from 5% for certain types of variances and 10%. It seems to be that whatever, they get a little more selective about that threshold. But not many cities that I found do a percentage and offer a minor variance as a general thing in the code. So to answer that question, but I have a lot to say about this topic when
Okay.
that's ready.
So I'll start off with, I guess, just sticking with the 20%. How is everyone feeling on the minor versus major and a 20% being that threshold marker?
It's okay with it.
You're saying yes? Yes, Commissioner Boyle?
Of whether,
Yeah.
is, how much of a difference does it make for the percentage versus the size of your city? Does that have anything to do with it? Would that come into play as making, I mean, what's the majority of the issues coming in? Because the whole point of this thing is to streamline and make it quicker. So if you're going to a hearing examiner, obviously it's gonna take a while. And so if we're trying to streamline this, then we want to find a number that's going to be able to bring some of the smaller things your way. So, I mean, and comparably, we've gone from 10% to 35%. So, I mean, if 20 sounds pretty fair for getting some stuff through quicker. Right now, it's, what is it?
Right now,
All or
there's only
nothing.
one variance.
There
for
is no,
everything.
and there is no minor
Yeah.
variance. Okay,
Yeah, and so.
that's what I thought I heard you say.
Um,
Hence why it's all in red and no blue lines crossed out.
And no blues for those. So yeah, I mean, like you said, you could do percentage, you could also just do an actual
Like a whole table?
whole amount, like, you know,
Yeah.
nothing, you know, if it's within 5 feet or 3 feet or whatever. But then again, both, again, pluses and minuses. If you're at 20%, so for like like I said, our frontage, it would allow staff to, it helps if I do it right. 75 times 2 equals. So basically, it would allow staff to reduce the frontage by 15 feet, from 75 to 60. It would require notices to the neighbors, but not a hearing. So neighbors would get to comment. There would be a 2-week comment period, but there wouldn't be a hearing for that. And then they have to meet the criteria. If, again, for our 8,000 square feet minimum, it would allow staff to, if they could technically reduce it up to 1,600, again, if they meet the criteria. So that brings it down to like 6,400. They could allow that. Again, notices would go out 500 feet. So that's up at the 20%. If you did 10%, it'd be half of that. It would be 7.5 feet. It could be reduced at staff level and 800 square feet at staff level.
So you would be able to reduce the lot from 8,000 to 6,400.
Yeah, but you'd have, again, you have to meet the criteria. You have to show, it can't, and that's where the conditions come in. It can't just be, oh, I want to.
Yeah, yeah.
Usually it has to do with, one, it does, again, it's hard because there is a little bit of that give and take. So it's a minimum necessary and different people can have different interpretations.
Was there a variance on that house on 15th and Milton Way to go up to 2 stories?
No, well, that one is because they, no, they can do 2 stories. That's fine. They're within the height. We can do 3 stories in ours.
They just couldn't do the bigger footprint.
Yeah.
Yeah.
Now, the difference right now between the minor and the major does say there are unique circumstances, which it does not appear that I had that in the minor. So if you want, you could add that to the minor.
Yeah, there's a few catch-alls in
It's
there.
always hard to know whether it needs to be the same criteria or do you have slightly different criteria?
Mhm.
You could
Yeah.
also have the same criteria if you felt like that there shouldn't be any difference in criteria, just the difference in the size. Again, I was looking at a lot of different cities on how they do things, and so at the time, this is what made sense, but that's
Yeah.
why it's for you guys to look
Yeah.
at and ask questions and decide if that makes sense for you.
Yeah. So I want to first say that I think variances first came up when we were talking ADUs like 3 years ago or so when I first joined the commission. So the idea that we're putting some authority in with staff for these things that are so minor, I really do appreciate that. And I think that's going to save a lot of headaches long-term. I think 20%, I like the fact that it's also a hard percentage, so it takes the vagueness out for you guys as far as first the applicant has to state, I looked at the rule and I am within 20% and here's my math, versus this is just what I want. I'm sure you get that either way. I'm comfortable with 20% and putting it in there. I think worst case is you get another planning manager in or somebody that says, well, if it's 20%, then just greenlight everything that comes through. So it's more about watching the criteria of, does it make sense? Do neighbors need to be notified? How does that work so that we're not creating a situation where all lots are now basically 6,500 for the sake of a round number instead of 8,000? But there are times where it just, we had someone that sat through a few public meetings about ADUs because their lot size was like 40 square feet difference, and staff just didn't have the authority to say, you're close enough, let's just keep going with it. So those are kind of my general comments as far as I'm comfortable with the threshold. I'm kind of anywhere between the 15 and 25% range I'd be comfortable with as far as going up or down from there. And then I also like that there's an option for a major and a minor variance. I'll continue just going around the room as far as comments, and I know you've got some general comments as well. I feel like I did skip you. I apologize.
That's okay. I just have
Okay.
one quick question.
Yeah.
I think 20 is a perfectly reasonable number. Is there any instance in which the variance would not be quantitative and a percentage would not apply? Or are these variances all in relation to area and size?
They're all, because you're, let's see. Somewhere in here it says, that it's not for uses and procedures. So the only time you're asking a variance is it's for setbacks, it's for minimum or maximum square footages. It's always going to be a number that they're reducing. So we don't, if someone says, well, I want a variance, it's single family, but I want to put a fourplex,
Right.
no, you can't request a variance for that.
Okay,
It's only numbers.
okay, thank you.
Okay. So Commissioner Whalen, if you've got any comments or, oh, yes, Commissioner Sweat, sorry.
I think the 20% is fine.
Okay.
And I think I had a question, but I didn't write it down. That's all I'll say.
Okay, and we were kind of sticking to the 20% if that was high or low. So it sounds like everyone's okay-ish with the range is the consensus I'm getting. But we are also opening it up to just also the general topic of whether we're in favor of a major and minor variance as well. And I know you have some questions on that.
So it is no secret that I really don't like variances. The rule is the rule, it's the filter, and I'm just going to be bullet point. I don't mean to be strident, but I look at our zoning code as a filter, and either your project gets through or it doesn't. It preserves a particular character, and so that's the mindset that I have in looking at variances. I look at our rules, they are not tightened, they are loosened, and that troubles me quite a bit. I've observed decisions over the years, decisions that are made internally, and spoken with planning staff afterwards. And this is, I mean, I've been a commissioner since 2002, so lots of opportunity for observation. And I bring forward and say, well, look, here's what the code says. And some planners have had the humility to say, oh my gosh, I never really thought about it that way. Other planners are a little more, less humble. I could point to projects going on through the years and just say, I don't know how that got approved. That doesn't make sense. And I'll leave it at that because I don't really want to put people of the past or future or present under any feet to the fire type of stuff. But I look at our code and then I look at a variance and say, man, it's pretty easy to undermine the rules. What's the point of us sitting here making rules? And so it's troubling to me to see that now up to 20% of a change can be done internally. And if you miss the sign, I mean, it's difficult enough to get comments in. And I've witnessed in the past, planners saying, well, whether you like it or not, it doesn't matter. Checks the box. Well, maybe we need to change the rules, but the rules a few times change. But I just wanted to review a couple things because there was a great question out there about, well, what will a variance apply to? When I look at page 13, purpose statement, it says in red, alterations to the requirements of this title. Title 17 covers temporary uses, conditional use permits, zoning code amendments, electric vehicle infrastructure, sign code. There's a lot of numbers sprinkled throughout our code. And to my dismay, I see later on in the code that to be more specific about what the variance does apply to is stricken. And that's on page 14, where under paragraph B, major variance, and what is removed is variance from bulk and dimensional provisions of this title called zoning. So that to me opens up, you could go to the hearing examiner or to staff for a variance on parking requirements, on the size of the sign. So I think we're missing some language if staff's intent is, no, we're only talking about bulk and dimensional regulations. That's been stricken here. And as I said, if you just look at the table of contents for zoning, there's a lot of numbers. If you do a search about variances, there's a lot of, in our code, there's 18 different places where variances come up in various sections. So making a change here is a big deal. I live in a neighborhood where, yes, the minimum lot width is 75 for the standard for making a lot, but the lots where I live were minimum, well, they were created at 90 feet before Milton even had a zoning code. The plat was approved before Milton was a city. And just that ability to make an administrative change to reduce lot width, to me is just really a big can of worms, asking for a lot of problems, and disrupting a lot of unintended consequences. So back on 13, I think 20% is just an extreme. That is an extremely high number to make a threshold, and I don't particularly like the idea of even an internal variance process. It needs to be more scrutiny, and it needs to have more public input. I see in 30, decision and appeal process, director shall decide on applications, explains the 2 permits. And then I look at page 14, review criteria and approval. And I do not understand why. Not only is it easier to get a variance because the standards are lessened than what you would do for a major variance. So to me, this is just like a slippery slope going way too fast in the wrong direction. For me, a variance should be based on criteria that says something in effect. A literal interpretation of the provisions of this title would deprive the applicant of all reasonable economic uses and privileges permitted to the other properties in the vicinity and zone of the subject property under the terms of this title. We do have a wording, the variance requested is the minimum necessary to provide the applicant with such rights. There should be wording in here that says granting the variance requested will not confer on the applicant any special privilege that is denied by this title to other lands, structures, buildings under similar circumstances. Our criteria should be much crisper. Variances shall only be issued upon a showing of good and sufficient cause. Variances should only be issued upon a determination that failure to grant the variance would result in exceptional hardship to the applicant. A determination of granting a variance will not result, and this is another criteria, it's only issued upon this criteria, a determination that the granting of the variance will not result in increased threats to public safety. The wording, extraordinary public expense, create nuisances, cause fraud on or victimization of the public. So, this commissioner, as I sit here, this is really softening the rules. And I sit here and say, what's the point of having rules if it's that easy to undermine them? Another thing and I'll give you an example. Minor variance, paragraph A, subsection 3. So one of the criteria does not constitute a threat to the public health, safety, and general welfare of the city. Give me an example of a threat. A threat. When I think threat, I think mortal danger. Give me an example where staff could say, oh, no, that's a threat to public safety. That's what I mean when I say, an applicant walks in and says, I want to reduce the maximum lot size. And then there's the give and take about what's the minimum. And I try to think, what? Just if it's bulk and dimensional type numbers, how could reducing a lot size create a threat to public health? That's my question to staff. What is a bulk and dimensional number that if it's reduced would create a threat to public health, safety, and welfare?
The only thing I can think of is like a fencing standard or something that starts going into the line of sight, or it starts impeding so much that you're now in conflict with international building code or residential code or something like that, as far as an immediate threat to safety or.
It was a rewording of, the existing term is materially detrimental, so we can, if you don't like the term threat, we could return it to materially detrimental. It would be something like if the side setback was so low that it puts it in a fire hazard with the, too close for building things. There's not a lot.
But that's also just one of the bullet
But
points that you have to
again,
go
it's
through, that it's a
language
yes or
that,
no.
for
It's
the
not a,
most part, is standard and is sort of a reworking of what has
yeah.
been here.
So I think you raised some great points as far as, is this creating a slippery slope of, are we loosening our restrictions to begin with, and then we're adding variances on top of that? And then with the variances, are we making it too lenient for staff to interpret it to where a developer is going to come in or someone's going to really take advantage of this and change the character of the city?
So the intent, I would like to address the idea of the bulk and dimensions. The reason it was pulled out is because at the time there's only one variance, and so I pulled that language out. The intent of the purpose, because it says it does not apply to table of uses and procedure requirements. I felt that covered that, but we can reword it. I guess there are other, I know that like the Public Works standards, they have an option for variances. It just sort of says variance. And so I think my intent was that this would help outline what that procedure is as well. But we can put the wording back in this under the purpose of bulk and dimensional regulations, if that, again, that was my intent, is to keep it to those things, is to not to do, and that's why I did table of uses and procedure requirements. I left that and I felt like that covered it. But if the commission does not feel like it covers that narrowly enough, wording can be added to the purpose. And then again, if there are suggestions of criteria, and again, if there's an option of just doing one set of criteria or two sets of criteria, if there's suggestions on that, it can be considered by the,
So if I could continue and just note that early this year, I want to say March or April, there was just an overview of the variance code and potential changes, and I've seen things get revised, and I appreciate that over time. But an example was given of a woman who wants to add on to her house. She currently has a substandard side yard setback. And an example of granting a variance, I mean, her reasoning was, I don't want to jog in my kitchen wall. And I think, and so that's what fuels my sense of, but that's such a aesthetic kind of reason. Gee, I don't want to jog in my wall, and so therefore I should be able to continue with the existing side yard setback. So I think you bring a good point that yes, there's intentions and we understand intentions, but new people come along and interpret the code. And that example just raised a series of red flags. And it was a hypothetical, I assume, but to say, well, yeah, you can continue with the substandard side yard setback. I just don't agree with that. That is not an important need. Someone could come in and say, well, I want to increase the building height by 20%. Well, wait a minute, we've got a measurement. Here's how it's done. We specify that in the code. And you want to increase the building height by 20% or more. I mean, they could go through the process of a major variance. But these are not compelling reasons. And then you have the whole issue of what if someone walks in and says, gosh, if you let me reduce the minimum lot size in a given zone by 30%, I could build more houses. And that's consistent with your zoning code that says this is a zone for houses. How do you argue, where is the protection here that says, no, that is not a deprivation of all reasonable economic? So for me, I want the language strengthened. I would, if a minimum variance is what the majority feels, this commissioner is firm on, that is way too big a number to have it be done internally. And I can tell you, because it's no secret, we've had a mayor who was a real estate agent, and that affected land use decisions in this city. I've witnessed it. So, that's another thing about having a hearing examiner. They're outside that kind of any type of a influence. And I'm not saying that's what's going on now, but I can point out the short plats. I can point it out to you. It's reality. History, past is prologue, as they say. So, this is, if you value a particular standard in your neighborhood or not, I mean, to me, that's a criteria to consider in these variances, to say, well, it's just a matter of a few feet. The criteria, I think, has to be a lot stronger. And like I said, someone walking in saying, I can build more houses for you if you let me go taller, put me on smaller lots. I want stronger, stricter rules. I want rules that say you can't set a precedent, that you're not granting special privileges, et cetera. So that's my feeling, and thank you for listening.
Of course. I want to make sure we continue the conversation and keep going around the room. Commissioner Sweat,
I'm good.
Vice Chair Oler.
Is it correct that we have a charge from the state to simplify this and allow reasonable use of land, simplify the permitting process, simplify these kinds of things? This is a response to that charge, correct?
It is to a point. Yes, in the fact that it does not specifically say you need to look at your variances or you have to look at your site plan, but within that realm of we need to figure out ways to make the process,
We're removing barriers.
removing barriers for things, then that is part of it. Part of this also was just the fact that it's something that has been brought up by the planning commission, and it seemed like this all sort of meshed together for me, that because we're looking at, by doing a minor variance, it allows us a process that is less complicated for things that are of less substance than of things that are major. So it's not a direct thing, but yes, it falls under that whole kind of umbrella.
Yeah.
I
mean,
will again say for the criteria, it does, and again, I made two separate criterias. If you feel like you want one, or we need to adjust things, that's fine. It does say both, the criteria is not, it can't just be because you want to be more profitable. It has to be consistent with the intent of the zoning. You could even say that, maybe add language that says, and it furthers the goals of the comp plan. If we don't like the word threat, we can have a different connotation. So again, it does not distract from the desired character. Minimum adjustment.
Area must be met.
Yeah.
All
so
of them.
It's not simply someone comes in and says it and they just want it because they want it. There has to be some more to it. And again, the example of the house, yes, it could be, but there is something to be said for,
What is it hurting?
it is more complicated. It's more whatever for their house. If it's a foot, you're only losing a foot of that side setback to make their house and the room that they're expanding. If it was me, I would probably approve that.
I mean, not having a weird looking house in my neighborhood probably is good for me as a neighbor in my
I
property.
don't see that being a huge detriment to the neighborhood in general, since that house is already, again, assuming that it's not. Now, if it was 1 foot from the property line already, if it was already non-conforming by a significant amount, and it's going to create a safety hazard with the adjacent neighborhood, then that would be different. So that's where that balance comes in.
Yeah, I mean, I guess my feeling is we're already dealing with a somewhat arbitrary idea anyway, just to try to draw the line so we can balance these needs 20%. I mean, I'm comfortable going down to 15% if necessary, but then the question comes up, how much work does this create for us, the lower the number is, so.
I mean, technically yeah, setbacks are arbitrary. It is what the community determined that they feel like is reasonable for this community, but those, there might be circumstances that that doesn't apply. So
Okay.
anyway, again, yes, if there's if there's consensus to adding some things or rearranging some things for the criteria, I'm definitely happy to address that if there's things that would be.
Yeah. I would say just kind of continuing the conversation. I like the idea of it being one criteria for major and minor with a threshold. It's just me pitching that out there as we're going around the table, just so that we're focused in on what's the criteria, drilling that down, and then just saying that this number is kind of where that's the threshold, whether it's 15, I'm comfortable with anything between 15 and 25. I'll continue allowing comments through, but just trying to make sure we're focusing and honing in on. So if you have ideas as far as if you like it to be one set of approval criteria versus different approval criterias, and then if there's anything you'd like to add into those approval criterias to really strengthen that and feel like we're comfortable or more comfortable with this minor and major variance idea. Commissioner Boyle, continue with you.
I appreciate the commissioner's comments. Not that it scared the hell out of me, but it definitely brought some different points to light that were made. And I think that if we could come up with a couple more criteria that made people more comfortable, I'd be open to that. But I think to expedite, maybe when this goes forward to council, that we let the council decide. We said that 20% is our max. If they can come up with some reasoning, some additional reasoning of why it should be, needs to be lower, I'm fine with that too. I mean, that would be ideal. I know we're supposed to make a decision and we make the recommendation, but when it's something that we're all kind of up in the air about, maybe we ought to step back a minute and get a few more examples of criteria that might fit and tighten it up a little bit. Because if we are going to create something like this, I mean, it's going in stone, so it should be done correctly, and we don't want to open up too many. Of course, we want to expedite the permitting process, but like was said before, we don't want to create that slope that everybody's going to start sliding down and finding these loopholes, and then it's all out of whack. You got people building right up to the property line, and what's the point of having a setback if you're going to keep reducing it? But I do feel comfortable with all the criteria that's here. I think they have a lot of teeth, but we may be able to nip a few in the bud of applicants trying to, beautify or whatever for their own advantages. If that makes any sense to anybody.
Perfect.
I could think on this,
Yeah, we
come
can.
up with a couple of criteria myself, I'm sure.
All right, well, let's continue around, and then we can also get into a round of if there's some suggested criteria or tweaks to the criteria here. Commissioner Zaro,
I'm good with the criteria, and I think 20% is reasonable.
okay. How do you feel as far as the idea of it being one set of criteria for major and minor with just that threshold, or do you like the idea of it being a minor variance criteria and a major variance criteria?
I think as it's presented now.
Okay, great. Continuing around to Commissioner Whalen.
I would rather see the one set of criteria And I would want it to be tighter than what we have under major variance.
Okay. Commissioner Sweat?
I'm good the way it's written at the moment.
Okay.
But I do, I agree with Tom about possibly having other criteria in here to keep people from trying to take advantage of variances. Because you know they will.
Okay. Vice Chair Oler?
Um, I don't have anything further. I don't have more criteria.
Okay. So it sounds like we're pretty split down the center as far as whether it's one set of criteria for minor variance, or sorry, one set of criteria for variances, which is that 20% threshold, or whether it's two sets of criteria. Does staff have an opinion one way or the other? Oh, sorry, Commissioner Boyle.
What about B5? Could we move B5 up to minor variance? That help?
Yeah. So I guess staff, do you have a recommendation one way or the other as far as one set of criteria or the other, or two sets?
My brain's trying to.
And just one point on that, 5 and 6 seem to go together in B.
Yeah.
Well, 6 is already in minor variance A5.
Mm-hmm.
So if you added 5,
So yeah, I believe I believe when I wrote this, there's a little less criteria for a minor variance, a little less of a threshold for a minor variance than there is for a major variance. So if you're comfortable that there's a lower threshold for the minor variance, then we can keep it as 2. If your feeling is it should be sort of the same threshold for both a minor and a major, just that they don't have to jump us through as many hoops, then we could very easily combine them, if that helps. So I'm not, like I said, that's basically the difference is, you know, is there is a little bit less of a threshold for a minor variance the way it's written.
Okay.
So if the feeling is you want the same threshold, I can combine them. If you're comfortable with having a little bit less threshold and it being staff, then it would stay roughly the same. But again, I've heard some things that we can definitely add, whether it's to the whole section. Like one of the things that was mentioned is that granting of the variance does not basically guarantee future properties have the same, doesn't create a precedent kind of thing. That would make sense to add, whether that's to the criteria or for just the general chapter. That makes sense. I was thinking we could look at, maybe a variance, if you want a variance, because sometimes like we have, there's some things in landscaping that, well, if you can't meet the criteria, you have to show us that you're supplementing somewhere else. So maybe in this case, that they would have to demonstrate that they are, with this variance, it meets it, but maybe that it's also furthering the goals of or something. If in certain circumstances, I don't know if that would always apply, but so again, that's kind of, I'm personally okay with either decision, but I would say that is how it is written, is it's a little less of a threshold for minor, and it is a much bigger threshold for major, or a bigger. I don't know if it's much bigger, but it is bigger.
Because sorry, to the mic, because when I look at the difference between the two, the big thing in the major variance was the unique circumstances, and I feel like that just applies in both cases, or I feel like it's almost just rewording the same bullet points, and so that's why I was kind of thinking it might be easier to just have it as one set. But if there's some intent to, yeah, and then and then bullet number 5 was the one that's really not on the minor variance, right? As far as the strict enforcement would create a practical difficulty or necessary hardship. So it's one of those where it's like, if you put 5 up into the minor variance, then you're kind of just looking at the same thing, just reworded differently.
Yes.
Am I kind of interpreting that correctly, or am I,
So you're saying
is,
5
am
on
I,
the top versus 5 on the bottom?
well, I'm just saying that if you look at bullet point B5 for major variance, if, as Commissioner Weil had proposed, if moving that bullet up to minor variance applies, then you're kind of looking at the same 6 bullets either way. They're just,
Might as well combine.
you might as well combine them. And
One set of criteria.
yeah, so that's the only reason I was kind of proposing that. But if there's some other intent that I'm not seeing with that, then we can keep them 2 separate. Does that?
I think
There
there's,
might be a simplicity to one set.
yeah, I like one set. It's just making sure that the verbiage that we have is preserved because it is slightly different for numbers 1 and 2 in both A and B. Reasonable use of the land versus that term isn't in B1, reasonable use of the land is in A1. In A2, you've got the verbiage desired character, nature of the vicinity. And in B2, it's more back to the idea of reasonable land, but it's not. It doesn't say reasonable. It says preservation and enjoyment of a substantial property right or use possessed by other property in the same vicinity and zone. So as long as we have, I'm okay with combining them as long as we make sure that we have the same intent and verbiage for anything on variance, and then we do away with the idea of major versus minor variance, and it's just variance. I'm fine with that.
For the criteria, okay. Commissioner Sweat, you look like you might have something to say.
Nope. no,
Okay.
I'm good.
Commissioner Whalen?
One question asked about, do all the following criteria have to be met? I would suggest that we add that. Paragraph B and A, it just says grant a minor or grant a major variance if the following criteria are met. I would suggest we add the word all of the following criteria.
That makes sense.
I would love to know a definition for substantial property right, what that really means. I've already said it ought to be 1 and it should be the major and variance standards and it should be tighter. I think there should be a statement that has to do with preventing public expense.
Okay.
And
Like monetary expense?
well, I would say monetary, like if someone gets a change done on, and again, the way it's currently written, it says a variance applies to Title 17. Title 17 covers a lot of territory, as I cited earlier. Even our environmental code, when you look for variances, it refers you to Title 17. So this has very far-reaching effect. There are many chapters that bring up variances, and it's just something to be really careful about. The other thing about the word threat, to me, that may be proper or current language, but threat to public health, that means, to me, that means somebody's manufacturing viruses in their garage. I mean, it's just like, what is a threat is a pretty strong number. And even materially detrimental, what does that mean? So some of these standards that, while I appreciate staff saying, hey, let's make this more clear and less, I think the word was squishy. some of these terms should be defined. And I strongly, strongly suggest that this code gets very specific about what exactly is subject to variance and what is not. And again, I go back to just the need to make that decision about whether you want really wishy-washy standards or not, and what that impact is. So I can submit the copies of the language that I read out as well to try to see if that would be a viable way to tighten things up. And I just will remember or cite an example of a time that we have new code. It was new to the zoning code of 1999, where someone came in prior to this new code and they made a literal jigsaw puzzle of lot lines so they could meet the minimum lot size. That plat, that short plat, when I went in to the community development director at the time, why did you allow this? I mean, you have discretion about these kind of things. Well, there was nothing specifically written in the code that allowed me to say no. And so if you look through the zoning code, and I don't have the number right in front of me, there is something in the code that gives staff the authority to deny a plat if there are more than 5 corners to a lot. So that was a situation where it was an internal decision made, the jigsaw puzzle was done, and it was all about getting another house on the property. That discussion came forward to the Planning Commission, and that created the new code that gave staff that authority. So I've just seen too many games played, and it's something that I hope fellow commissioners are persuaded by my comments to just say, making a significant change to minimum lot size is a big, big deal. That will be a very big change. And we won't really know about it until the concrete's poured and the walls are up. Thank you.
Sorry, I'm just thinking, so minimum lot size maybe could be something that we set in stone, right? And say variances do not apply.
Except for the fact that, one of your examples was that, for someone who's slightly under for,
Oh, sorry, I'm thinking of just for the single like just for a plot, sorry. Yeah.
but again, I think that's where it comes back to, again, variances are always going to have a level of discretion. And yes, you could always have that rare exception that for whatever reason got through. Most of the time, those would be very exceptions, and I would just, and even the one that's got weird lot lines.
Okay. Sorry, it was half a thought out loud, and also I didn't follow the process. Sorry.
You can't, you want to try to do the best you can,
Okay.
but you're never going to be able to, there's always a chance of something going weird
Yeah.
because someone will come up with something.
Yeah.
But I think that, we don't, if we look at the criteria, I can perfectly happy, I can combine it. We can, look at, you want to find that balance between allowing people, because there are weird things with properties that are not going to be detrimental to the city or even that neighborhood as a whole. It might even blend in with what
Might
the
even
other
make it better.
properties are doing around it. So there is some discretion there, whether it's the hearing examiner or the staff, you're always going to have that. So you're trying to balance that. But like I said, I will come back with, I will look at making sure I think what I have heard is making sure that we're very clear on which parts of the code a variance can qualify for a variance. Coming back with one set of criteria that maybe adds a little bit to it. And
And adding the little notes
Yeah.
that if all the following.
So
Okay.
we'll come back with that. And then we will, I will have these as, each one of these chapters will come as a separate motion for recommendation. And they will be discussed and approved separately by city council as well. Because as much as it's nice to kind of group them for discussions, they are different chapters. And so that
Okay.
we'll do each one.
Great.
Is there anything else on?
Yeah.
I'll be
And I'm
brief.
going to put you on a
Yes, thank you.
timer on that just because we are at 7:40.
So just to give you an example of why it's important to specifically state what the variance applies to, I'll give you an example. In our definitions, we have a definition for substantial change in use. Substantial change in use means a use deemed by the land use administrator as substantially different in character to the use previously existing on the site. Determination that a use is substantial in change in use, the land use administrator must find that trip generation of type of traffic, parking and circulation, utility demands, environmental impacts, physical space needs, and clientele characteristics of the use differ by more than 10% of the characteristics of the use previously existing on the site. So that's just one example of, so there's a safeguard, there's a guardrail, 10%. You make us, if you change the characteristics by more than 10%, it's a substantial change of use, and there's a chain of events that go on from that. So to say that could apply, a variance could be applied to that, that's the way this code is written, because it does not say it excludes definitions. And also, our definition of variances may have to change as a result, because the definition for variance means an adjustment in the application of specific bulk, dimensional, or density regulations. So it's something else I'd suggest getting looked at to make sure that the two are congruent. Even concurrency review for traffic impacts and such. And there's a lot of numbers in the zoning code. So I appreciate fellow commissioners saying, and staff as well, saying, we'll get more specific. Thank you.
Okay, great. So as far as action items go, staff is going to revise it per the tweaks that you mentioned. If anyone has any recommendations on criteria points, let's try to get that to staff within the next 2 weeks so that you have time to incorporate that and then get something revised and sent out for next meeting. Now that we're kind of at like 7:43,
So the only other one, again, I think we just basically touched on it is, and I don't think, so basically 1770 has a listing of application requirements. Not all cities have this. It is something that would help, helps kind of identify for applicants what is required. It also allows, one of them is that additional information required by this, requested by the city. So it's not, it's open-ended if there's other stuff. So all we've done is, or what all I've done is kind of gone through and changed the table to match what we're actually requiring people. And this, like, Pierce County Sewer does not offer a certificate of sewer availability. So it's just changing the wording to proof of sewer review. So they will provide an email that says, yes, we're reviewing it, but they won't do the other. And then again, say some of these, again, just trying to match what in practicality we request or we don't request. It did add, if we're major and minor, what was required for site specific. The only other thing would be, again, rewording it from engineering and utilities to civil site development, because we do require them to do a civil site development permit in most cases. And then I want to say, maybe not. Yes. And then it is suggesting that we remove plan unit development because it's not something, we no longer will have that zone. And we don't, I think, have any code that actually identifies someone doing a plan unit development. So, and it's currently blank anyway. So that's all that, for the most part, that section. And I did, I believe, run it through the attorneys to just, or not the attorneys, the engineers to say, does this make sense for what you want? And they said yes. And then, like I said, all of these documents I currently have with the attorney to look through, make sure he's not seeing anything. And then I will bring him up the other topics that Planning Commission has brought up.
I have a point of clarification on page
Yep.
24L. There is an addition that says drainage report added to the submission for a proposed comprehensive sign plan. Does that mean also that they need to submit a drainage report that they did not need to previously?
Yes. That makes me think maybe the engineers added that. Because I'm not sure that I would have added that.
Is it under the signage? The drainage report is under the signage. What does that have to do with
Are you talking about signage?
on page 24L, what she's talking about?
So she's under L for the final plat of site plans, PUDs, master plans.
Yeah, I brought it up. It just seemed like an odd inclusion.
Yeah,
that
I will
just
double
saying-
check where that came from.
Okay.
Yeah, don't let those utility guys mess with your little form. Just throwing stuff in.
I'm
there.
wondering if they meant to
This
put
looks
that
like
as
a
an
good line.
extra bullet, that that's supposed to be like a new M.
Yeah, let me look and see where that came from and why that's there.
All right.
I think that was meant to be a new letter, not a component of L.
Yeah, and I'm not sure where it's under final because usually we require that early on. So yeah, let me find out where that came from. If that was something I erred at or if they included it, and then I'll find out why.
Okay. Yeah, that was my point of clarification because everything else from what you described is just an editorial change or rephrase.
That's a great catch. All right. So as far as homework for that is, I guess continue to review it. If you've got any comments or questions, go ahead and send them to staff so that we can be more efficient and ready for next meeting. Anything else as far as under agenda items 7B? Permit procedures for this topic? We're good? Okay. So 7C, we added to the agenda as far as scheduling for additional meetings. So if anyone needs to get phones or calendars or anything out, feel free.
So we have two actual dates to look at. So the first is actually our next meeting is scheduled for October 9th, but I was informed that that is the week of the holiday bazaar, which means we do
Not again.
Yeah, not
We do not have a facility on October 9th because they start to set up here.
Priorities, people.
I know.
I
You would
agree.
think that we would.
I agree. I agree.
Be a good time for a public hearing, I'll tell you what.
We would have lots of people there. So, on that note, so we can bump it to the Tuesday. We could I think we could bump it to the 16th. I don't know what people are feeling on that one.
So Tuesday, the 8th, or Wednesday, the 16th?
It's kind of what I'm thinking, because my guess is, I don't know that I have all the calendars here that I wish I had, but I think I'm okay. Let me see. 'Cause my guess is the following Wednesday is probably events committee, but they probably won't have their meeting because they have just done the holiday bazaar, so we could take their spot, I think.
So basically, we'll just tell them we're swapping spots with them. Okay.
I'd have to verify that, but I think.
Well, I
that's-
think we just tell them they stole our room. We get to steal theirs back. So the options are the 8th or the 16th. Does anyone have any restrictions for either of those days?
I usually have physical therapy, but I can cancel
On the 8th or the 16th?
on Tuesdays and Thursdays.
Okay, so the preference would be the 16th?
That would be my preference, but
I take it back. It's the park board meeting that's on the 16th, so.
Oh, so we'd be looking at the
I can,
23rd then?
I can make it work. The 8th.
Or, I mean, yeah.
So what are we talking about now?
So we can't do, yeah, so we can't do October 9th. So we could do October 8th. We could probably do October 15th, which is a Tuesday. Or we could do October 17th, which is a Thursday.
So 8th, 15th, or 17th. I'm available all of those. I do prefer not the 15th because I'm coming back in town that morning. Anyone have any restrictions as far as the 8th, 15th, or 17th?
Not me.
Yes, Commissioner Whalen?
I would lean towards the 17th as my first choice.
Okay.
And the second comment would make is, as was brought up, priorities. Why is it that the bazaar boots us out? I just have a real problem with that.
For a standing agreement.
I mean, I understand they want to make the room, set up the bazaar, et cetera. Why can't this room get set up after our meeting? And I just think it's disrespectful for the planning commission that we have to vacate our meeting, and we only have to vacate it because of the recording device. So just a standing comment that the bazaar needs to respect our responsibilities here. And I would weigh in on the 17th for this year.
I'm free on any of the days, and I am happy to move my schedule around to allow the community event to do their thing.
So what's the deal? Are we all boycotting the craft bazaar and we're having our meeting on the 17th?
Start on Friday? They need this room Wednesday? It starts Friday, right?
They set up, yeah, they
Yeah.
start setting up on Wednesday and then everyone has to bring their stuff in on Thursday. It's a very, and they have to do both room. I don't know. I just
Okay.
know that that's what they've done. I'll be selling stuff at the craft bazaar.
Oh,
so I, can't
Oh.
boycott
I guess
it, so sorry.
the boycott, the boycott has been
But
lifted.
yeah.
Okay,
But so,
So everyone
is the
come and-
17th sounding okay for everybody?
yeah,
on
it
the-
sounds like 17th is the
Okay.
preferred date.
17th?
Yeah.
Okay. And then when I was talking to Framework, we felt like we wanted to do, throw another event in or another meeting in. I have jury duty the last week of October, which would have probably been the better choice. So, but I can't guarantee that I will be available that week because I already pushed it back to then because they wanted me in August and I went, there's no way. So Framework was happy to come on the 6th and then come back on the 13th. The thinking would be that we could hold the hearing on the 6th for the zoning items. Then that would mean that we could come back on the 13th with hopefully final versions that could be recommended. So they'd come in October, they'd come, we'd hold the hearing, and they would come November 6th and after the hearing, we can have further discussion with the hope that by the 13th, we would make that recommendation. So does Wednesday, the 6th work to have? It sounded like most people emailed me back that they could do that. So just double checking if that's set.
Day after the election.
Oh, yay.
At least it's not the day of the election.
Yeah.
I've been here for a council meeting on that day. Awful quiet.
So, are we
It may
okay with
be,
that? 16th and then the 13th of November, or 6th and 13th of
Number
November?
what?
November 6th and November 13th.
Yes.
And then by then, maybe we will have adopted everything.
Yeah, maybe.
Then we can take December off.
Yes.
I won't be here anyway.
Somebody's
Oh,
going on
wait, but we
vacation
have
over here,
elections
so-
December, or does that mean elections would be November?
We could, or yeah, or we could do it in January
Or January?
and just, I open the, carry over, so, but yeah.
I would be all for finding a way to
take a month off. You guys have
Yeah.
worked really, really
Yes.
Because we did not
There's
get a.
3
we-
meetings in October.
Excuse the
3
summer,
meetings in
right? Usually-
October. I mean, I'm sorry, yeah.
Yeah,
2 meetings, well, yeah.
2 meetings, okay, yeah, that's right,
Yeah.
I'm sorry.
Just
Two meetings in
a
November.
comment, November 6th, first Wednesday of every month, I have a pretty heavy-duty commitment, so I may not be there. I will try my best,
okay.
so.
Yeah, I got a pretty tight schedule too, so.
Well, it's not a tight schedule, it's a
I'll make it
heavy
happen.
commitment.
If you, Commissioner Whalen, if you so desire, because you're going to miss that and you feel like there are issues that you would like to discuss with Framework prior to that, they said they would be happy because with the zone code to set up a meeting. So if after the October meeting, you feel like there's things that you want to continue to address before that, that would be fine.
Thank you, I appreciate that accommodation very much and welcome other commissioners to join in on that opportunity. And as I said, I'll make my best effort to be here on 6th, but that's my status.
All right.
Thank you.
All right, moving into staff reports.
So just a follow-up, we had another round of discussions with the city council, with the land use portion and the future land use map. They did have consensus. There was the area along 70th that is currently multifamily, and in the proposal, it was being recommended to go to more the neighborhood residential. And so they did have consensus to keep it that multifamily, which is now called urban residential. We also had identified when I was going through the zoning review that there is on the northeast where the urban trail kind of cuts across 161, there's a little triangle piece of property that the city owns that they received grant money for that is supposed to be tied to the urban trail of some sort. So they gave consensus to change that to open space because it is not going to be houses. It's going to be a parking lot or something tied to that. We also, staff had requested to add a land use goal that basically, one of the things staff has talked about is, and it's also some of the state mandates, is to continue to improve our relationship with the tribe. And so they have given consensus to add just a goal that says that the city council or that the city will consider there's basically land acknowledgements that a lot of the cities in Pierce County and King County have done. It's a way to have to basically say, we understand that this has traditionally been tribal land. Our hope is to use that as a way to continue to engage with the tribe. I know Fife has a great relationship with the tribe, and they've been able to, Pure Elk Tribe has supported Fife in their discussions with Sound Transit and getting grants. And so our hope is to move towards getting better relations. And so this was one of the things that we suggested. Other than that, there wasn't much else brought up there. One other on a project, there's there's sort of this hangover semi-truck parking. I don't know if people were aware or not aware, that off of Meridian up by the trailers, that was one of those areas that was still light manufacturing, even though everything around it. Anyway, the hearing, so it went to, they've applied to do it in 2020, and they just kind of kept going back and forth. It's been dragging on. It went to the hearing examiner. We did have, and again, it was a conditional use permit, so it wasn't allowed outright. It was, and so under our model, that would stay as a public hearing for something like that. Anyway, all that to say is based on the comments at the hearing, the hearing examiner requested additional information from the applicant. Based on that information, they felt that it didn't meet the criteria, and they have denied that. So I don't know yet if the applicant will appeal it, but it is. At the same time, that is an area that the Planning Commission has recommended changing from light manufacturing to neighborhood commercial, neighborhood business. I got to learn all the new terms myself. And so we had actually just passed a moratorium because those things don't seem to fit there. So assuming that it doesn't get appealed and overturned, that project is going to die. It was denied. And because we have that moratorium in place, nothing else can be put in until we get the new zoning and future land use maps. So
Said that's on Meridian?
it's on, yes, it's on Meridian above, right above Airstream.
Right, so
where-
it's north of Airstream, and it has a driveway, and then it has a pretty new fence that says new homes for sale on it.
Yeah, which I have
And then it has
never
the,
understood why it says that because I've never gotten an application for new homes.
then it has the, of course, the typical yellow Milton sign
Which we will
like
work
this,
on.
that I was right next to it, and I looked, can I read it? Can I read it? No, the piece of paper that was in there had blown out and was gone.
Oh, okay. So yeah, so just kind of some updates on stuff going on.
Thank you.
Great. Commissioner reports. Vice Chair Oler.
Not for me tonight.
All right, going around the table. Commissioner Sweat,
Got nothing?
Commissioner Whalen,
It's not so much commissioner activity, but I just want to note for the record, this is the 23rd year anniversary of the 9/11 attack, and it's a somber day. And just, my heart goes out to those who've been traumatized and have lost loved ones in that attack. And I just wanted to make a note to just send those folks some love. Thank you.
great job with Milton Days. And then also that means that around the corner, we've got the holiday bazaar or craft bazaar, whatever it's called now. I never know the political terms for anything anymore. And then we also have the Santa parade, I would assume, coming up shortly after. I think we fell behind the ball as far as being able to create a float or anything. So if there is any interest, feel free to email me through the city thing. If anyone's interested in putting together a float, we did it the year it was super freezing, had a lot of fun. Made some snowflakes out of hangers in your case and put boot box on trucks. It's not that overwhelming, but if anyone wants to make some South Park Christmas animals, I think that's what we're going with.
Are you
Christmas
guys- so
critters.
You got like a trailer that you tow around, or?
We just put it on the bed of our truck.
Oh, okay.
So is what we were thinking for ours. And then if we could get groups together, my husband's on the Parks Board as well. So we were kind of trying to make a double date out of it with other people that were on.
Would be cool
commissions
if
and
like,
stuff.
somebody could get hold of a shuttle bus. That way it's got a heater inside. You can
Yeah.
slide the, I didn't say party bus. I said shuttle bus.
Staff took just one of the city cars last.
Oh, yeah.
The
Yeah.
finance director and I just went in a city car and threw candy,
Yeah.
so we could be warm.
And if people want to be
Yeah,
involved,
we'll
they,
lay out
I believe there, if you want to go around, there's cops. You can ride with the cops. I rode with a reserve officer one year, and
Yeah.
it's fine, as long as you don't have to sit in the back.
Yeah, I think it's a really fun opportunity as far as doing the parade or just any of the community events. You start seeing the amount of kids we have in the community and the people that are really excited and active and want to participate. And I think when we're trying to represent everyone or think of it, it's just nice to get outside of our bubble and see what a great community we have. So that's my little pitch as far as if anyone's interested, email or call, text, whatever. But I'd like to get that going because we kind of missed our chance last year. Commissioner Zarro. I'm promoting you apparently.
I have a few questions for you after the meeting about some developments in the city, and then just don't let me forget. And yeah, Milton Days. None of you were there. That's fine.
I was there. I was a roadside ranger.
Were you there? Why didn't you guys, anybody come up and say hi? I had to bug Angelique all day.
I was getting yelled at by all of the roadblocks led everyone to me in my final roadblock.
Oh, yeah, she was one of the parade.
I was one
Oh.
of the roadside rangers
She
and
was nice and let me through.
yeah.
It was probably, it was one of my favorite years that I really didn't, I take Friday off to help set up
Yeah.
and work with the city guys, and that's always fun. But I wasn't like, this is my funnest year that I wasn't like on the committee.
Mhm.
And so just seeing them, the way they do things now, there was a ton of kids the kid zones. And the thing is I'm up on the upper part of the park and we hardly saw any kids because there were so many kids down below with all the different arts and crafts and the climbing walls and all that stuff they had. They had like a foam axe throwing thing for the kids. It was it's always something different. I went and saw the petting zoo that they had on Friday. I stopped there and they were doing hot dogs and everything. And yeah, really great event. I mean, just everything ran smooth and it was good to see. I mean, Angeli and I are in our street clothes, although my street clothes are about the same as as these clothes. But yeah, it's cool. You know, and I see people I went to high school with that still come to the event. And so, yeah, it was excellent. So that's all I got.
All right, great. So I think that takes care of commissioner reports. Again, our next regular scheduled meeting, we got bumped, so we are going to October 17th at 6 p.m. With that, it is 8:06.